Welcome again, everyone. This webinar is brought to you by the Ohio Employee Ownership Center and the Ohio Employee Owned Network, located at Kent State University in Kent, Ohio. We're a nonprofit training and outreach organization located right on the campus of Kent State. We focus on ESOP transitions and training. Today we have Dale Vlasek of McDonald Hopkins in Cleveland, Ohio. The title of his presentation is DOL Enforcement and ESOPs, Current Issues. Dale, take it away. Dale? Dale, are you there?
The conference has been unmuted.
Can everyone hear me?
Yes.
Okay.
Yeah. Okay.
Dale, can you hear me?
Yep, I can hear you. I didn't show up as muted, so I'm not quite sure. So.
Okay, Dale, take it away.
All right. Thank you. And good morning to everyone who's joining us today. What I plan to do for the next 50 or so minutes is touch on the Department of Labor and their role with ESOPs and things that are of current interest and things that they are focusing on as we go through these next few years. To start, just let me spend a couple minutes on background, make sure everyone is on the same page in terms of the Department of Labor and its role and where its focus is. Employee stock ownership plans, I think as everyone who's on this call are aware, are governed by the Employee Retirement Income Security Act, ERISA. And the Department of Labor is one of two primary government agencies that are charged with enforcing ERISA. The IRS is one, and the Department of Labor is another. And if we're talking about defined benefit plans, you got the PBGC. But PBGC is not involved in ESOPs, but the IRS and the Department of Labor are. The IRS and the Department of Labor approach this in two different ways. The IRS, as you can understand, are tax collectors, and their role is to make sure that the ESOP, in terms of the tax benefits that it is providing the employer and the tax benefits that it is providing employees, are satisfied so that those tax benefits can be applied, and if they're not, they go in and collect whatever the appropriate assessment is in terms of tax. So the Department of Labor's focus is on compliance with the tax laws. The Department of Labor is different. The Department of Labor's primary concerns are protecting the participants in terms of their rights and benefits under the plan, whether it's an ESOP or a 401k, and they are charged with dealing with the fiduciary responsibility sides of ERISA. All the fiduciary responsibility sides fall primarily into the hands of the Department of Labor, and so that is their focus. And I've mentioned in other conferences and talked about the Department of Labor has a different mindset, a different culture. And if you haven't been through a dealing with the Department of Labor primarily by means of an audit, or maybe a disgruntled participant has caused the Department of Labor to give you a phone call, the Department of Labor's focus comes in, they're crusaders in a sense, and it's part of what they're imbued with. That is, they're trying to protect participants. And so I have told clients that Department of Labor comes in and their mindset is employees are getting screwed here somehow, and if I just dig hard enough, I'll figure out how it's happening. So that tends to be their mindset. So you've got to look at what they're doing and realize that's how they're approaching it. Let's talk just for a couple of minutes. Well, we talked about the Department of Labor being charged with dealing with fiduciary duties and people under the plan. Well, it is always helpful to know who are the fiduciaries of the plan. And simplistically, a fiduciary is any person or entity who's got discretionary control over the plan or has control over the plan assets. Not so much in the ESOP context, you need to worry about it, but they are people who render investment advice for a fee, or they've got discretionary authority or responsibility with respect to the plan. Well, who are they? That's a nice legal definition that's right out of ERISA. Who are we talking about? Well, we are clearly talking about any person or entity that is named as a plan trustee. It is the plan administrator, and by plan administrator, we're talking about typically the employer that's sponsoring the plan. And we're not talking about the third-party administrator. We're not talking about your record keeper. The plan administrator is a defined term under ERISA, and the way ERISA is written is the employer sponsoring the plan is the plan administrator unless somebody else is named. And in 99% of the time, maybe even more than that, it is the plan administrator. Technically, it is the plan administrator that signs your 5500, as well as the employer. Often it's the same person signing in two places, but the plan administrator is typically the employer. It is also anybody who's a member of an investment or administrative committee. A lot of ESOPs are set up such that you may have an outside trustee, professional trustee named, but then there is a body of people at the company that serve on the ESOP committee, administrative committee, whatever you call it. They're typically going to be fiduciaries. Their role may be limited. They may have limited responsibility, but they're typically going to be considered fiduciaries. If you've got some investment manager who's running the other assets that the ESOP may have, they will be a fiduciary. And then what people tend to forget sometimes is the naming of a fiduciary is itself a fiduciary duty and responsibility. So anybody who selects or appoints any of these people is a fiduciary at a minimum with respect to the naming of that person. So your board of directors often are the ones who name the committees, or the board of directors of the company is the one who names the trustee. And that decision, that naming, is a fiduciary decision. There is no test in terms of consent. I didn't consent to be a fiduciary. I just came onto this committee. There is no consent required to be considered a fiduciary. If you are performing any of the duties we talked about, or if you have effective control over the activities listed, you are going to be a fiduciary. And it can have some unintended consequences for folks, just so you're aware of. We dealt with a situation once years ago. It was not an ESOP, but it did have company stock involved in it. And one of the issues, if you will, one of the people who are part of the, they wanted to make sure that they had someone around who could sign things, and so they named the secretary to the chairman of the board as being on one of the committees, the idea being that she was going to be there to sign things when everyone else was gone. Well, that is fiduciary authority, and so therefore she got dragged into an ugly lawsuit, even though she really was there more to help things out, but she did technically have the control. So she got dragged in with a lot of large employers. A question was presented about are members of communication committees typically going to be considered fiduciaries? If their role is more just communication, that is the idea they're just presenting information out to the workforce, and really don't have any control or any authority over the plan as a plan, they're probably not going to be fiduciaries. All they're doing is communicating. Now, certainly that's an important component, and they would certainly be charged to make sure that the information they're providing is accurate, but that's not, in and of itself, is going to rise to the level of being a fiduciary. Give you the recitation of fiduciary duties. Kind of the critical ones is under ERISA, if you are a fiduciary, you've got to act solely in the interest of the plan participants' beneficiaries, with the idea of you're providing benefits to the plan participants and defraying reasonable expenses. And you've got to act and make decisions like you knew what you were doing. This is sometimes called the prudent expert rule. That is, the idea is you're supposed to act prudently, but not just with an empty head, if you will. You've got to act like you know what you're doing. If you're charged with investing plan assets, and here in the ESOP you're going to be charged with investing in company stock. You got to minimize the risk of large losses. Now there is an exception in the diversification area when you're dealing with an ESOP. And then here you need to be acting in such a way that you are acting in accordance with the plan documents. Well, that's the background, and that is what the Department of Labor is trying to enforce. In recent years, the Department of Labor has increased its enforcement activity. Its budget had been increased a little over 12.5% between 2011 and 2012. Don't know what's going to happen now that the sequester has kicked in, if there's going to be any reduction, but there has been an increase in Department of Labor's budget. They've increased their number of employees. They have 460 Department of Labor investigators in 2012. So there are a lot of people out there. They all seem to be in Cincinnati, but I don't think that's true. They're scattered across the country, but there's a lot. There were over 3,000 civil investigations that were closed, which meant they were actively looked at and a resolution was completed in 2012. 72% of them resulted in some type of monetary amounts paid to plans or to the department, or some corrective action taken. Now, just so you realize, when the Department of Labor comes in, they will look to find something. It is very, very rare, as you can see from this, that they leave without something. Now, sometimes the corrective action is the problem they found is relatively minor, like you didn't have a fidelity bond, which you needed. Technically, that's a violation of ERISA. And sometimes, even if you have a fidelity bond, it doesn't clearly and expressly name the plan, the ESOP, as one of the named insured. And so that's a violation, and the corrective action would be to demonstrate that you've named the ESOP as a named insured. So you will see that, so that counts. But sometimes they're more serious. Sometimes they will involve making corrective actions, making payments. A lot of this stuff is kind of collectively looking at both ESOPs as well as 401ks, and often the Department of Labor has, and we'll talk about it a little bit later, has been very active in making sure how fast you put your 401k dollars into the plan, and some of those penalties relate to that. Well, if the Department of Labor chooses you, that you've been unlucky enough to win that particular lottery, what is their hot buttons? What are they looking at? What are the issues that they will address without question? Well, the first, always, they are going to look at the valuation. The valuation in any ESOP is always the weak point. It's because we're dealing with privately held companies. We're dealing with stock that is having a value created by professionals, trained professionals in virtually every situation. And that determination of value is, although it looks a little scientific, is more of an art than a science. And so there is a lot of leeway in terms of appraisers. And so they will always look at that. And one of the things that is a requirement in terms of ESOPs is the assets of a plan have to be valued at least annually. So you're going to have an annual ESOP appraisal done. And then you're going to have an appraisal done when you have transactions that involve a party in interest or a disqualified person, typically the employer or a selling shareholder, that are involved in a transaction with the ESOP. You're going to need an appraiser or at least some type of a bring forward letter. So they'll be looking at those. Well, when the Department of Labor comes in, they look at the appraiser. Under the law, the appraiser is required to be independent. Has to be an independent evaluator. And the Department of Labor will look to see if that's true. Is there independence? Who is this person? Who is this company that has been engaged to do this? Do they have connections with the company or the transaction? They need to be totally uninvolved with that. And For the most part, that's usually not particularly an issue, but there can be situations where it does not look good. Who is this person? You don't have to go out and hire a totally large organization, although I think there's lots of good reasons to do that, but you can hire anybody who's got the competency to do this, but it shouldn't be someone who's got some relationship. It shouldn't be your brother-in-law. It should be someone who's got the credentials that is independent. You can't have, in my mind, if you're getting bank financing, you can't have some firm that is related to the bank being your appraisal firm. You don't want to have that kind of stuff. So that needs to be looked at. The next step, once they determine that there's independence here, and in most cases there is, it's not usually an issue these days. People are very conscious of it. They will look at the qualifications of this particular appraiser. What is it about this person or this firm that gives them the credentials to be able to do this job? And some of it, certainly can be all the string of initials that people have behind their names. It can be the training they have. It can be all of those types of paper credentials that are there. But some of it can be experience. This person has been involved in this industry for 25 years. They know it. They get it. They can do this kind of thing. This is a person who values businesses, not a person who does house appraisals. This is someone who can do this kind of stuff. So they have that. But then the Department of Labor starts to dig a little deeper oftenly, and they will look to see, well, was this person appropriate when you did the ESOP deal 10 years ago, and you're continuing to use this person or this firm, and now you've tripled, quadrupled in size. You're in 15 different states now. Is this person still the right one? Has the company outgrown the appraiser? That's not an easy question, not an easy answer, but is this something that is out there that you need to look at? So they will look at the appraiser themselves. They will look at their credentials. Beyond that, they will also dig into the report that you got. They will look at the methodology that the appraiser is using. Now, once again, doing appraisals is an art, not a science. There are certain traditional hallmarks, standard things that employers that will use and appraisers will use and the Department of Labor will look at. So the Department of Labor will look at the methodology your particular appraiser is using, and they will compare that against the typical methodology, or what at least the Department of Labor thinks is a typical methodology, and they will poke at it. The Department of Labor will tell you that they have no problem if you're using something that is unorthodox, something that's a little unusual. They will tell you that that's okay, but they will poke and push very, very hard at that. So they like to see things. They have certain training. They have people in their back room that will look at these things and will compare them against what they think is the correct methodology, although they will never say that to you, but that's what they're doing. And so if you're going to be using something different, maybe you've got an industry that is unique, that you've got a different role, that the standard stuff doesn't work, you can certainly do it, but be prepared to receive some resistance from the Department of Labor and be prepared to be able to defend what it is you're doing. So just to warn you about that. Well, once they start looking at it, are there particular hot buttons that the Department of Labor begins to challenge when they look at appraisals beyond the methodology, beyond the standard of care or the standard of scrutiny that the appraiser has? Well, first of all, the things that they will hit you on or make you defend is, is there no discount applied for lack of marketability? The Department of Labor expects to see that in a plan. What is it? And if your appraiser is not applying a discount for lack of marketability, they better be prepared to explain why that's appropriate in this situation. They will also question if there's a failure to take into account the risk associated with having a single large supplier or customer. That is, you've got one major client, one major customer, and if something happens to them, you're really going to be hurting. That needs to be something factored into the appraisal. They will, if they see that as part of the narrative of what's going on, they will push hard on that and expect to see some adjustment made for that. Inflated projections. That's one of the things where we all like to puff things a little bit, and you're probably basing your company's value on what you anticipate the company's going to be doing in the next several years. What are your projections? What do they look like? Are they realistic? And so, in theory, if we're looking at this with hindsight, and the Department of Labor may be coming in 3 years later and looking at an appraisal from 3 years, and you had some projections about what your company was going to do, and then everything went down the tubes. If we're looking at projections you did in 2007 and in 2008 hit and everything went to hell, you're not supposed to be able to look at it with hindsight, but it's really hard not to. And so they will say, well, those projections were inflated, obviously, because you didn't do that. Well, no one did anything in 2008. So they will look at that. And some of it is just like dumb mistakes that people should have caught, if you will. They will look at inconsistencies between the narrative of the valuation and the math and all the appendices that are involved. Are you using, what are you saying, or did you just tack things together? This is last year's appraisal just with a couple of updates and didn't track anything out. Same thing as the use of outdated financial information. It should be current. Should be looking at current information, current projections, all that kind of stuff. Improper discount rate. That's always a difficult one because that is more of a feeling of what seems to be appropriate. And the Department of Labor may think it should be a particular number, and the appraiser might think it's something else. You can get into some interesting discussions about that with the department if they start to question the valuation. But that's one of the things they will look at, so your appraiser needs to be comfortable with the discount rate that he or she is using and be able to defend it if they need to. Same thing in terms of comparable companies. What are you using for comparable companies? And are they really incomparable companies? A large public company comparable to a small private company. Sometimes, and I don't have to tell you this, that there really isn't anybody you can compare yourself to, and you don't have information about other small privately held companies, so you do the best you can. But if there's too much reliance on things that are incompatible, it could be a problem. And then they will always look to see what some of the underlying assumptions are in terms of how this appraisal is being done, and is the appraiser testing these underlying assumptions, and are they accurate? So they will pick at these things. Certain things, depending on your appraisal, will be of more interest to them than others. Well, what should you be doing? Well, besides looking at the actual appraisal itself, the Department of Labor then turns to the fiduciary side, because the trustee is the one who is charged technically with valuing the stock that's held in an ESOP. We tend to kind of blur that, but that's not how the statute's written. That's not even how the plans are written. The trustee makes the decision. They use and have the need to use an outside appraiser to make that determination, but the trustee makes the determination. And the Department of Labor, when they come in and they audit you, they give you a laundry list of things that they want to see. And one of the things they always ask for is trustee meeting minutes. If you're not doing that, if you aren't having regular trustee meetings, if you've got internal trustees, you want to do that, and you want to have it documented. I find in most cases clients are doing it, but they may be a little sloppy about writing these down. So if you've hired an outside professional trustee to do it, I can guarantee you they're doing it because they know that's part of their job. They know that's what they're getting paid for. But if you're doing it internally, and there's certainly no reason that you couldn't, although best practice is moving more towards using outside professional trustees, but you can certainly do it inside, and we've got a lot of clients who do, that you're going to want to have trustee minutes. You're going to want to have trustee meetings. And one of the things that they are looking for in those meetings is what are the trustees doing when that appraisal comes in, when that valuation hits their desks. Are they looking at it? Are they reviewing it? Have they asked the firm to either physically come in or be part of a conference call and explain the valuation to them rather than simply accepting it and rubber stamping it? And it's a good practice to get into, to have those conversations with them and to ask questions about it. If the valuation moved up or down, why? Are these assumptions accurate? Are these valuation comparisons that you're doing accurate? Just push back at it and record what it is you've done, what their answers were, and make that part of the minutes. It is just a good methodology and good practice to get into. It'll help you. And it'll also be enlightening to you. Although it's not a requirement by any means, it's not in the statute, but it's become a more and more best practice, if you will, is to periodically test that valuation company. That is, if you've hired an outside good, reputable company, that's fine. And you like working with them and people are comfortable with them and you like the results and all of that is working well, that doesn't mean that you shouldn't kick the tires every once in a while. It doesn't mean you have to replace them by any means. Not at all. I'm not trying to imply that. But every once in a while, it's not a bad idea to have somebody who knows what they're doing take a look at it. Engage some other professional who's got knowledge in the industry, who does appraisals, to look at what your current firm is doing and give you an opinion of if they're doing a good job, if you will. Not necessarily redo the whole valuation, not to to do all that, but to look at and give you a sense of is what this firm that you've engaged doing things that are acceptable professionally? Are they making the right assumptions? Are they using the right comparables? Are they using the right discount rates? All the things that we talked about earlier that the Department of Labor is pushing back on, have somebody who knows what they're doing tell you that. And if they aren't, if they say, well, they're using this, but really the standard of the industry is to use Y, then you can ask them about it. Mostly, if you've got a good professional organization, they're going to be within the professional standards, but it's a good idea to every once in a while just to test that. Now, one of the things we've suggested to clients in doing this, because one of those issues is, well, what if I get the answer that is they aren't doing a good job? That's where they come back and say to me, if you want to have some protection about that potentially, is if you have your attorney engage the outside person on your behalf, so essentially the report is going back to the attorney, you can take the position that information is privileged and does not necessarily have to be shown to the Department of Labor. Kind of one of the last things you'd want is they have some report from a firm that helped you evaluate your appraiser. It tells you they're doing a terrible job, and then you didn't do anything about it. Now, if that information comes back to your attorney and says they're doing a terrible job, then you're certainly going to want to talk about it. You're certainly going to want to decide whether what it is that the problem is and whether or not you should need to address it. If the information comes back that everything's okay, well then fine, you take it and have the attorney give it to you and put it in the minutes, but you need to address it if the answer comes back that it's not what you want it to be. Besides looking at the appraiser and the methodology, if you will, of the valuation, the Department of Labor has been focusing lately on loan documentation. Most ESOPs, at some stretch during their life, are leveraged, sometimes multiple times, sometimes over multiple years. And the Department of Labor, until recently, it kind of ignored that for the most part. At least that was my experience. But within the last 10 years or so, and the activity is picking up, is they're spending a lot more time looking at the loans that were involved. They are looking to see what the loan documents between the ESOP and the company, or between the ESOP and the selling shareholders, really say. Now, in particular, they're looking to see if there's any prohibited provisions in the document, because there's a list of what you can do and what an ESOP company, ESOP selling shareholder loan can look like. And there can't be things that would be ordinarily commercially reasonable, because that's sometimes how this slips in inadvertently in the heat of a transaction. It's been my experience that ESOP transactions may start out slow, but they tend to pick up in acceleration as you get closer and closer to closing, and sometimes things might get a little crazy, and maybe inadvertently things slip in. And sometimes, if you're using people who may not have been as careful as you need be, or maybe haven't done an ESOP transaction in the past, things may slip into documents that would be commercially reasonable in normal transactions, but are not going to be permitted in an ESOP transaction. And a couple of things that they will always look to see is what happens in the event of default. Now, it's kind of hard, very honestly, for the ESOP to default, because the ESOP relies on the company to put the money in. And if it's borrowed the money from the company contributes it, puts it in the ESOP, turns around and pays it back. It's going to be hard to be a default. So no one focuses on that. And very often there is a provision, not very often, but from time to time there's a provision that may accelerate all the scheduled loan payments in the event of default, which is commercially reasonable, but it's not what you can have in an ESOP document. An ESOP loan document can only be the payment that was missed gets accelerated. The rest do not. Also, you can't have additional interest for late payments. Once again, commercially reasonable. The Department of Labor won't let you do that. Some loans have been adding, permitting the voting rights for the shares in a suspense account to be controlled by the lender in the event of default. That may or may not be an issue, but what you've done, if you think about it, is you've now made that lender a fiduciary, because that lender now has some control over a small piece of plan assets, that is the voting rights of the stock, effectively can be seen as a plan asset. It's a benefit of the plan, and now you've got them having to vote in the plan's interest, not their interest. Once again, that would be a commercially reasonable thing to do, but creates some issues in the ESOP context. Now, a lot of loans, and my loans do it as well, and I think most people, you add language in there kind of tucked away in there that says, well, if there's anything in this document that would be in violation of ERISA, you treat this document if that provision wasn't there, you make any decision in such a way that you don't violate ERISA. Most ESOP loans will have that language in there, just kind of a catch-all. In case we missed something, screwed something up, we won't do anything that would cause this thing to violate ERISA. And if the Department of Labor is in there looking at your loans and find these problem areas with the loans, pointing them to that language and say, well, I know it says that, but this provision says we won't do that. They won't buy that. That mitigating language, they just don't accept. They just totally ignore that and say, yep, you got a problem. Now, the good news is they're not forcing people to unwind these transactions, or to do anything, or to cause them to be treated as prohibited transactions because you didn't follow all the technical provisions. What they let you do is amend the loan documents, other than it being a pain and everyone looks a little foolish. It's not much of an issue, but they're out there doing that. So. They're also looking at loan administration. They want to see the actual mechanics of what's going on when you've got loans and loan repayments. They don't like paper-only transactions. By that I mean you've got employers supposed to put a contribution in, and the plan is supposed to turn around and pay the contribution right back to the employer. And there was a tendency in the past to say, yeah, I know that's what it says, but what we're going to do is, well, I'll pretend they put it in, they pretend to give it back to me, and we'll just cancel the stuff on paper. Don't be doing that. The Department of Labor wants to see what's actually what's actually happening. They want to see the money going in. They want to see the money coming back out. They want to see an actual pattern of contribution and repayment. So avoid simply paper transactions. Just go ahead and do that. They want to, and they will look at the actual calculation and the actual release of shares. So they will look at your principal and interest payments that you're making and making sure that you're releasing an accurate number of shares. Sometimes you can have some bizarre results depending upon programs you might have in your computer. A lot of people have built spreadsheets or they use programs in terms of calculating interest and things like that that you might have in your Excel spreadsheets and programs like that. And there might be some discrepancy. And the Department of Labor may nitpick you on that. We had that situation with a client of ours that they had a spreadsheet that said X amount was paid, but the Department of Labor when it calculated had a different number. And so we had to make some modest adjustments. More of a pain than anything else, but they will look at that. They will also look if what's happened as part of the loan that the actual stock certificates, the stock and suspense account has been given to the lender to hold as security. We've got some who do that. I tend to like to leave it in the plan, but sometimes they insist on it and the lender wants it. And if you're doing that, you've got to be getting stock back every year. So you've got to be issuing new stock certificates. So you're going to be reducing the stock certificate number of shares that are being held by the lender as security and transfer things. They want to see that pattern. Once again, you've got to be very accurate. You've got to work your way through this stuff. So they will look at all those kinds of things. Here we're going to shift just a little bit into not only the ESOP side, but part of their focus these days in terms of plans generally, your 401k plan as well. If you've had a 401k plan, you were very actively involved in this last year, was plan expenses. Your various service providers in terms of your plans were supposed to tell you what they were charging you, and then you were, especially in the 401k arena, supposed to be telling participants what their plans were being charged. Now you don't get a whole lot of charge in an ESOP typically because there's not usually a whole lot of cash inside the ESOP. So there's no cash to be able to pay plan expenses out of. But if you are paying plan expenses out of this plan or the 401k plan directly, the Department of Labor is pushing back on that. They went to a lot of trouble in their minds creating these regulations that are having the service providers tell you what the charges are. And what they want to know is, okay, now that they've told you this, what are you doing about it? Your provider told you. Your plan is paying for it. One of your duties as a fiduciary is to not pay more than reasonable compensation for services rendered. Doesn't mean you can't pay for things, but it's got to be reasonable for the services. So they're going to want to know, you got this number, did you look at it? What is XYZ company doing for your plan or your ESOP? And was what they are charging reasonable? We want to see that. Now that's new, it's still developing. We don't know how this is going to shake out because this is a relatively new phenomenon, if you will. But that's one of the things that they will ask for as part of an audit is, what did your service providers tell you? Show me the paperwork they gave you last year. I want to see it. First of all, they're checking to see the service provider provided it, and then they're going to ask you what you did with it. Last, in terms of kind of other plan DOL audit focus is 401k deposits. It doesn't matter if the 401k plan is part of your ESOP or is a separate standalone plan. The department always, when it comes into audit, you will ask you about your 401k deposits and how fast you're getting them in. People have gotten much better because everyone's been beating you over the head about that for the past several years. But they will ask and always suggest no matter how fast you're doing it, you probably could shave a little more time off of it, but just be prepared for that. And besides simply the 401k deposits, if people have borrowed money from the plan, usually ESOPs don't have any loans for participants because once again there isn't any cash for them. How fast the loan repayments are getting back in as well. We're going to revisit the definition of fiduciary, trying to keep us back on time here. One of the things that was a big issue in the past is the Department of Labor had proposed to include the independent appraiser as a fiduciary. They released that proposed regulation. It included lots of other stuff, and then everything got put on hold. It just created a firestorm of protest, not only in terms of the appraisal community, but some of the other stuff that was part of that regulation, and that all got put on hold. Post-election, I think the Department of Labor is feeling a little empowered. It feels that it's got its agenda and it's got the administration's support, and so they are going to be reproposing the definition of fiduciary, and part of that will be going back and looking at treating the appraiser as a fiduciary. I did listen to a talk by Phyllis Borzay, who's in charge of this area, and she was pretty insistent that they're going to come back with something, but they may be willing to make a distinction between the routine annual valuations that an appraiser does and say, for purposes of that, the appraiser is not a fiduciary. But if you got a transaction and you are absolutely totally relying on the appraiser's determination of the value, then the appraiser is going to be a fiduciary. So it would be a fiduciary for transactions, not a fiduciary for the routine. What does that mean as a practical implication? I mean, right now, the appraisers certainly have liability. The appraiser is in a contractual relationship with the trustees, generally, or the employer, and so they've got a contractual duty. They've also got a professional duty to do things correctly and to do things in a professional standard, and not to commit malpractice, if you will. So what happens? Why is it a big deal to add the appraiser as a fiduciary? Well, what it does is a few things. First of all, it has personal liability to the appraisal person, appraisal firm, if you will, to the extent that they are considered to be a fiduciary, so they have personal responsibility. It opens up the possibility, and here's where the Department of Labor is coming in, it opens up the possibility of Department of Labor penalties. And then I didn't list it here, but if you think about it, by making the appraiser a fiduciary, you increase the number of people who can sue them. Because if it's simply a contractual matter, then the trustees can sue them for a breach of contract or malpractice. But if they're fiduciaries, then every participant in the plan has the ability to sue a fiduciary, so they could sue them. Well, what it's going to do, as a practical matter, it's going to increase the cost. Appraisers aren't going to get out of the business. We're still going to have to use them. But if they're going to have more responsibility and more access to getting sued, they are going to charge more for it. And so it's going to increase the cost of running your ESOP. It's going to increase the cost of your transactions. I fully expect that this is going to come out in another proposed regulation, and we'll have to see what happens with that. Last on my list of topics, and this is something that has been happening at least with more and more frequency of late in terms of ESOPs, and I think it's a very positive matter. And one of the things, I think it's a function of the fact that maybe the economy is turning around, companies are increasing their valuation, stock prices are going up. Because what it is that ESOPs are starting to look at removing company stock out of the accounts of terminated participants. If you think about it, most ESOPs are run kind of in a traditional way, that if somebody leaves short of normal retirement, disability, or death, we typically wait to the end of till after the end of the 5th plan year after they leave, and then we start paying them out. And we pay them out over 5 years. So you've got a 5-6 year delay before you start to pay them, and then you start to pay them out over a period of time. If you're leveraged, you can wait until the loan is paid off, or they hit one of the other events before you start to pay them. And so you sit there. They're sitting there. They can't access their money. It's not like their 401k plan where they can get paid out 20 minutes after they leave. You're going to wait. And it is a way, and it's designed the way the law is written. The point of that is to permit companies some time to build up the cash flow or to anticipate, because you don't know necessarily when somebody's going to terminate employment, and it gives you the ability to kind of be in a position to pay them. What we've been seeing is a feeling, especially as companies have rebounded, as their stock price has continued to grow, and you've got somebody who left and who's sitting there, and in the minds of the active people, they're going, you know, they're riding on my coattails. I'm doing all the work, and old Stan is sitting there not helping at all anymore, and just getting an increase in the value of his benefit based on the hard work of all the active people. That's a little different philosophical message than we've seen in the past, and more companies are looking at doing something about that. The purposes of this whole thing and cashing these people out is to eliminate the ability of the terminated participant to share in the increase in value of the company's stock. Well, is it a, you know, how do we handle that? Well, typically it's handled in either of two ways: a reshuffling provision, where essentially that, all right, when a person leaves, we take the company stock that was in their account, and we take it out of their account, and we put it in the accounts of the other folks that are there. To the extent you've got some cash build up inside people's accounts, or you've got a contribution that's going in that generates the cash, you take that cash either out of people's accounts or out of the contribution that's going in, use that to create the liquidity inside the person's account, and then take the stock and put it into the accounts of the active people. That's a reshuffle. The company could also go in and redeem the shares if they wanted, with the employer repurchasing the shares of the terminated participants and putting cash in, and the company takes the stock back and then either recontributes it. So either one of those ways are the methods that I've typically seen. Probably, depending on the company and how much cash, you use one or the other. Well, is there a problem? Is the Department of Labor going to be interested in that? Is it some type of discrimination against the terminated participants? Well, typically it's not going to be. Participants under ERISA don't have the right to be in a particular investment. That's not part of their accrued benefit. The amount that they have, if I've got a person who's got $50,000 in their ESOP account when they terminate employment, and I can convert them, they've got a right to $50,000. So when I convert them, I've got to make sure that I got $50,000 sitting in that account when I'm done with it. The fact that it's no longer $50,000 worth of company stock is okay, but at the minute it's $50,000 worth of cash, I'm good. I have not violated ERISA. So the Department of Labor shouldn't care about that. But it's the next step. If I'm not going to pay them out, and a lot of companies aren't willing to pay them out, even though you've accelerated your purchase liability one way or the other, if you will, and I don't want them to get it any sooner than they would have gotten it had it been in company stock, so I'm still going to make them wait the 5 years, and I'm still going to pay it out over the 5 years. Well, now I've got a duty. I've got to do something that, in my example, with that $50,000. I simply can't let it sit there without investing it. The trustees have an obligation to invest that money. And there's some choices, and some of it is a function of how the plan is designed, and some of it is a function of how you want to run things. You could, the trustees in an ESOP typically are in charge of all the employer stock that's in the plan. There is no participant direction of that at all. That's all controlled by the trustees. And to the extent there's a limited amount of other investments or cash investments, we call it sometimes inside the plan, the trustees often run that as well. Well, this, in my example, the $50,000 we just took out of this person's account and put it back, took the stock out and put cash in the account. It's got to be invested. The trustees could direct that investment. They could direct that in the same manner, in the same way that they direct the other cash investment, the other investments inside the ESOP. Now, they have a bit of fiduciary responsibility there. They are in charge of doing that. They've got to operate that $50,000 in the best interest of the participant and the participant beneficiaries if something were to happen to the participant. So they have to do that. And that's fine. There's no violation of ERISA. You just realize that we've got to do something like that. If we've got a lot of people build up into that situation, maybe I'm going to hire an investment manager for that. But that is a fiduciary duty. You've got to do something with that. Well, a lot of fiduciaries tend to be a little uncomfortable with that situation. And the idea is, I don't want to be running this person's money. I'm okay with running the stock. I don't want to run this other investments. And now, as we are starting to cash more and more people out and not paying them, I get a little uncomfortable trying to run their money for them. I'd rather not do that. And do we have alternatives? Well, you do. A lot of ESOPs, every ESOP I think everyone on the phone call knows, has got the requirement under the law to permit diversification of certain portions of company stock over a period of time, starting after their age 55 and have had at least 10 years of service inside the plan. You could probably just overlay those same procedures, same options on this. One of the options not being the distribution, but the option of letting people diversify, either have funds already inside the ESOP, which is my experience that most ESOPs don't do, but could create at least 3 different funds inside the ESOP and let people choose among those. Or what often happens is, well, we already got a 401k plan, I'm just going to take and transfer that money over to the 401k plan, and so just like I would do with the person who's taken advantage of diversification, I will take and move that money over to the 401k plan. There's no right or wrong answer to that. It's just a matter of how administratively it works better for you. You can continue to leave it in a plan, invest it. You can create funds inside if you don't want to do that, or take and move it to the 401k plan as an option, if you will, in terms of that. There shouldn't be any particular issues with that. You get into the situation, and I've had conversations with clients in terms of, if you're doing that and cashing people out, do you really want to hang on to it? Most of them still do, and so most of them still want it to remain in the plans because they don't want these people to get something the actives aren't getting. And especially if you're not letting people take distributions while the loan is out, even though you've cashed them out, you leave their money there. And so with that, Jay, I think we've got about 5 minutes left if we want to.
Yes, we've got some time left.
Questions?
Great presentation, a lot of information there, and we do have a couple questions. You see them, Dale, in front of you?
I do.
Okay.
And kind of a question. I guess I kind of implied that it might be better to use a larger firm as your appraiser. And to the extent I was doing that, I was not trying to imply that. I think it's very often easier to defend a larger firm because the Department of Labor definitely uses any of the ones we all know in terms of their own, so they have some credibility. But there's no reason that you can't use a smaller firm or a smaller person. There's no legal obstacle to it. But what you want is, if you're going to do that, you're going to want to make sure that you can defend their credentials. And I know in particular industries, there's some people that are just known to really know that industry, and it isn't the big players. And so I have no problem with you using other firms, smaller firms or individuals. Just realize that you're going to want to be able to justify that if you need be. Other question was regularly held trustee meetings. Should we be doing that? And my answer is yes. We ought to have regular scheduled trustee meetings. Now, in terms of an ESOP, things don't happen there isn't usually a lot of stuff that goes on in terms of ESOPs and how they're run. So at a minimum, you're going to want to have at least one meeting a year, and it should be timed at the time that the appraisal is ready to be reviewed and accepted. In my mind. And so you're going to have at least one, and you're going to have one where the trustees are looking at and accepting the appraisal. Other than that, there probably isn't a whole lot that's going on out there in terms of how frequently you need to have meetings. Obviously, if there's a transaction that the ESOP trustees need to be looking at, you're going to buy stock from a selling shareholder, you're going to want to have meetings related to that. But other than that, other than the at least once a year meeting where you look at the appraisal, probably on the ESOP side, you probably don't need more than that in terms of regularly scheduled. Now, if the ESOP is somehow combined and it's got a 401k side to it, if you will, You're probably going to want to have more frequent meetings with respect to any 401k investments that you have. But in terms of a pure ESOP with very little other investments in it, probably once a year is fine. Maybe twice a year would be a good thing to do. Question about Department of Labor inquiries regarding repurchase studies and a frequency of repurchasing studies. I haven't seen any specific requirements the Department of Labor has on those. Clearly, that goes to your fiduciary duty as the trustees, because you got to pay these people out, and so you're going to want to have a sense, and clearly the company is going to want to have a sense of when is my money going to be needed to pay people? Because having an ESOP is a little bit, maybe a lot like having a defined benefit plan. You've promised a benefit, you've got to pay for it at some point. So I've seen the Department of Labor ask if you've had them done, but I have not seen them say that you need to do it every 2 years or 5 years or update that. But it's a good practice to get into because it really helps the cash flow of the company. It certainly helps the cash flow of the ESOP. Question about the ESOP 401k transfer option. Well, what if your 401k plan is a SEP, the other option? I haven't seen that done so much because typically a SEP is an IRA. It's really just an individual IRA that's set up for everyone. It's kind of controlled a little bit by the company, and the company is putting contributions into it. So if you were to allow a distribution with the cash out to the SEP, the company's going to lose control over it, if you will, in the sense that once you put it in the SEP, the employee's got total control, and if wants to pull it out the next day, he or she can do it. There's nothing the employer can do to stop it. So I've not seen that ever used in conjunction with an ESOP. And if that's your only option, I guess I would not let the money leave the plan. If you're going to do that, if you're going to be willing to let them put it to the SEP, I would just let them take the distribution, cash them out, let them take the distribution. Don't wait the 5 years. You'll be in exactly the same situation.
Did you see
there was I'm sorry, not a SEP, a separate plan. I have seen it. Yep, I'm sorry. I apologize. I have seen it done with separate plans. I have seen the transfer done. And what you're going to do is you're going to want to make sure the separate plan, because it's still going to be, if you will, ESOP money moving over, you're going to want to carry over some of the rights and features that the ESOP has, like the ability potentially to ask for a distribution in company stock, and even though you've cashed them out. They still, by law, have that unless you're an S corporation or you restrict it only to actives. You've got to protect all of those rights and features when you move. I've never really seen any participant ask to get company stock, but you'd have to protect all of that stuff, even in a separate plan. So, yep, I have seen them both ways.
Great. Thanks. We had one further question regarding availability of the slides. Dale, would you share those?
I'll be glad to share them. Yep. If you send me an email, let me know.
Well, let's do it this way. Yeah, either send an email directly to Dale, and let's advance this slide here. So there's Dale's email, or you will be receiving a feedback email following the close of the session today. And you can just indicate in that feedback that you would like a copy of the slides and put your name and email in that feedback form, and I will make sure that Dale gets those, okay? Well, thank you all for attending. We're just about out of time here. I guess I have a question, Dale. How long does a typical audit take? And what, if there is a typical audit, and what kind of resources are taken up from the company in order to support the audit?
Well, and there probably isn't a typical audit, if you will. I mean, the way these things usually transpires, you'll get a notice, sometimes a phone call, sometimes simply a letter saying we're coming in to audit you. Then you're going to get a letter from the auditor saying, well, we'd like to have this information. And it's like a 2-page list of some of the things that, pretty typical, copies of the plan document, copies of the determination letter, copies of the valuations, stuff like that. Things over the a lot of times over the last 3 years. One of the things that always kills me is they ask to see your 5500s for the last 3 years, and part of me goes, well, we file them with you. Why don't you have them? But you wind up giving it to them. And so there's a bit of time in terms of resources for the company in terms of collecting that information, and how long that takes very often is a function of how big the company is. So you pull all that stuff together, some of which they want to see beforehand, and they are willing these days to get it electronically, so you're able to scan it and send it. You don't have to mail hard copies. But then they also start to get into some of they ask for things that are part of the nitty-gritty, account statements, trust records, things that may be a little more difficult and a little more voluminous. Sometimes they want to see just a collection of different things in terms of payroll and things like that. And so it can be pretty thick. You wind up kind of collecting maybe, I'm not exaggerating too much, almost like a foot of paper at a minimum to give this guy or girl, if you will. But sometimes they ask for things that are, to get a little crazy. I'm dealing with one right now where they wanted to see participant statements for the past 3 years. And so they said, we've got 5,000 people. Do you want 5,000 statements? And so the auditor said, no, I'll pick 5. Okay, so you can do that a little bit like that. So there's going to be, maybe a couple days worth of time of somebody collecting the stuff for them. Then the auditor will always make an on-site visit and spend some time going through stuff that you just made available to them but didn't send them ahead of time. They will always then interview various people involved with the plan. They're going to want to talk to the trustees. Sometimes they'll let you do one trustee. Sometimes if you've got internal people, they're going to want to talk to all the internal trustees. They're going to want to talk to somebody who's got some knowledge of how the administration of the plan happens. And we're not talking about your third-party administrator outside. We're talking about somebody at the company who's intricately involved. And we all have probably a pretty good idea who that might be, and it's probably all the people that are on the phone call today. They're going to want to talk to you about how this thing operates in practice. Now, the way these interviews are conducted is that they're conducted one-on-one. The Department of Labor person is interviewing you or whoever the person they've asked for. Now, you are allowed to have a lawyer present, so the company's lawyer can be in the room with the company's lawyer. Can't be answering the questions or doing anything like that, but sometimes it's helpful. I mean, you know this. In the ERISA area, we speak a jargon, and if you've got somebody, one of your trustees who isn't as involved in this as you are, they may not realize what's being asked of them, and sometimes they come across. I've sat in these meetings, come across looking a little, to put it bluntly, dumb. Like, really, you're a trustee and you don't understand these questions? But some of it is just a matter of translating it for them. So that may take, depending on how many people they want to interview, another day, 2 days. Then my experience is they go away, and you don't hear from them for a long period of time, and then they'll come back up. They'll send you a letter, or they'll give you some indication there's either everything's okay, or there's some issue they want to spend a little bit more time on. And that's where the time, you go back and forth a little bit, and they have this tendency to like vanish and then reappear 3 months later out of the clear blue. I joke with some people, it's like if, I don't know the crowd here, but you remember the old Columbo TV show with Peter Falk? It's like, oh, and one more thing, just one more question. It's kind of like, that's kind of how they approach it a little bit. And so they go back and forth, and ultimately it does get resolved, but it can take sometimes a long time because they vanish. Although I'm dealing with one right now, different one, dealing with one right now, and kind of the agent hinted that the end of March is like the end of the the first quarter of the fiscal or the first quarter of this year for the Department of Labor. It's almost like a car dealership. If we can get this closed by like the middle of next week, we can get this all resolved. So we might be willing to cut you a better deal than we would if you push us into the next quarter, because we can report it as closed. It'll look good on our compliance reports back to Washington. So you got to factor those things into it too. So.
But it is a process.
It is a process. It is usually not quick and easy, and it drags. And you'll respond to their questions, and it vanishes into this black hole.
Yeah. Real quickly, we're almost out of time. Audit insurance. Do you have any comments regarding audit insurance?
I haven't seen it used much. I've certainly seen fiduciary insurance used. Audit insurance. Not a whole lot. I know there's some third-party administrators out there, if that's what we're talking about, that offer, if you will, say, look, if you're audited, we'll defend or help you up to X amount of dollars. I have seen that, and it's just really just a matter of they should be helping you anyhow, but it's a question of whether they charge you for it or not. So I'm not sure if that's what they mean by audit insurance. So.
Thank you, Dale, so much. A lot of great.
You're welcome.
I want everybody online to be aware of some of our future events. Hopefully you're getting some information from me about those. Coming up on Friday, we have another webinar that'll be focusing on ownership culture with Chris Mackin of Ownership Associates. That's this Friday. And on the 12th, which is next week, Dave Gustafson at Apple Growth Partners will be talking about appraisals and valuations, but he's going to put a different spin on it. The title is An Appraiser's Perspective on Acquisitions. We know acquisitions are a hot topic in ESOP circles, so Dave's going to talk about his experience with valuations and acquisitions. And of course, April is the time for the annual OEOC conference in Fair Lawn, and that will be the 18th and 19th of this year. So we want good attendance and your participation in that. First, I want to make a brief apology. If you've been checking our website, the website is up. However, there are technical issues with it, adding information to it and changing information. We're having difficulty refreshing information, so it's kind of frustrating for us. I'm sure it's frustrating for you. If you need more information on any of those events, don't hesitate to call us directly or call me at 330-672-0998, and I can get you links to more information and registration. Hopefully the site will be refreshed here within the next week or so. Okay? And again, a reminder that you'll be getting a feedback form through email at the close of this session, and give us input so we can improve our sessions. Also, if you would be so kind, if you have multiple viewers at your location, I'd really appreciate knowing how many viewers we get. Our funders like to know that, and my records only show those individual registrations, and we know that often you put a bunch of people in a room and you all view from the same computer. So if you could give me a feel for how many people in your company are actually viewing these, our funders would like to know. Okay? And with that, I think...
Thank you. Please stand by.